Check one, two. Audio check one, two.
We're going to call the public hearing to order. Welcome. I'm Greg Hedda. I'm the co-chair of the Higher Education Committee. Sitting here to my left is the Senate chair, Senator Slapp. Joining us online is one of our two ranking members, Representative Haynes. And I know there's a lot of things going on in the building, and so we have members who will be in and out of this hearing as their schedules permit. And so, but we're pleased that we have a list of folks who want to comment on the legislation before us today. And the first on that list is Representative Tim Ackert from Coventry. Representative Ackert, welcome to the Higher Education Committee. We miss you as a member of the committee, but we're waiting with bated breath to find out what you have to say about one of those.
I miss it dearly. And as sometimes you know, that aren't our choices of what committees we have. To my leadership, I do like the Higher Ed Committee, if you think about any changes in the future. But Senator Slapp, Senator Mar, Senator Kelly, Representative Haddad, Representative Rochelle, Representative Hayes, and esteemed members of the Higher Education, Employment, and Advancement Committee. My name is Tim Ackert. I represent the 8th District, which includes Bolton, Columbia, Coventry, Lebanon, and Tolland. Thank you for the opportunity to submit testimony on the following bill of today's public hearing agenda, Raise Bill 302, an act expanding the tax credit for qualified apprenticeship training programs and establishing a pilot program for children interested in trades. I have submitted proposed bills in previous legislative sessions to various committees that contain expanded opportunities for apprenticeships in the trades. I've also been supportive of the need to bring additional awareness and interest to our youth to become involved in our trades and the numerous opportunities in the apprenticeship training program. And I commend this committee for doing just that, bringing this to the forefront. I think one of the areas that we look at in the state and under this administration that there has been a great expansion of apprenticeships in education and in childcare. We've had the state of Connecticut has great apprenticeship programs, typically in trades and in manufacturing. And this bill actually expands some areas that would provide tax credits. And I appreciate that. I do have some suggestions on changes. In the area on line 80, you have the carpenters I have worked with myself, the union carpenters worked with myself to increase the credit from the existing $4,000 for the company to the $7,500 to match the manufacturing tax credit, which is also in the plastic manufacturing area. And also, that's what also include for all the other areas. So it's an opportunity for people to be encouraged to hire people in education, in other areas like the childcare providers also I had mentioned, but also to give the trades incentive to hire more apprentices, which we sorely need. In addition, I'd like to add section 3. Let me preface this. In section 2, this bill looks to start to introduce the trades at an earlier age, and that's in middle school, which really what you should do. I'm at an age where we had home ec and shop class and really enjoyed those. And that was an introduction for individuals, obviously to take care of their home, but also to be involved in other trades other than going off to college potentially. And also that expansion, I believe, is getting more people involved and interested. We have a hurdle in Connecticut. And the hurdle in Connecticut is that we limit the amount of apprentices in our trades. So when we look to expand them in other areas and incentivize them in manufacturing, we actually choke it off in Connecticut by having hiring restrictions, unheard of anywhere else in the country. So I suggest, in addition to this, add section 3 of SB 302 to amend the section 20-332B of the Connecticut General Statutes to eliminate the apprentices to licenses table and insert the language that the apprenticeship to license ratio should be the same as the on-the-job site of 1-to-1 for hiring sites, for hiring and for job sites. Thank you for the opportunity today to share my thoughts and suggest changes to Senate Bill 302. And I look forward to consideration of my remarks, and I look forward to this bill moving along. I know there's a lot of good positive testimony in this. I did notice that Senator Bartolomeo, in the past life, that Commissioner Bartolomeo had some opposition, and that's happened so often that they're set up with a budget that they have to stay within that parameters. But I think there's other ways to get this legislation to its fulfillment without costing the Department of Labor more dollars. So thank you again, and thank you for all that you do.
Thank you for your testimony. I'll ask other members if they have a question, but I did just want to ask you about what you just referenced with respect to the position of the Department of Labor. They say that they will need additional staff to sort of manage the additional workload. You just made reference that maybe there are ways that we can accomplish the same goals without. Are you suggesting that we can do that without additional staff members? Or I'm just expand a little bit on what you just.
Yeah. So right now, the apprenticeship program is handled from the department. I have met with Todd Birch is the gentleman that runs that area. And right now it's a simple form that you fill out, you send back, and they check off. I actually have the forms as a sponsor for apprenticeships. Have finally, that I'm aware of this legislation. Again, we do great legislation in this building, and that sometimes we don't promote it. What I think should happen is that when a sponsor, that's what we're called, sponsors, actually completes an apprenticeship, you submit to that Department of Labor, they just check that off. They essentially say, okay, they can now test. At that point, they let you know, they can just say, okay, you've completed that, and essentially sends you the form that says that person, that apprentice, has completed their apprenticeship. That's really all they need to do. So I don't know. It's an acknowledgement that they'd complete their apprenticeship program and send, and I wish they would do this, email you the form that says you can now fill this out and get approval that you can now get the tax credit. So it is a separate step, but I think that department has the ability to do that now and has done that. So I don't know where the additional, without talking to the department again, that's on that section. The instruction component is actually more in our schools, but also I know that there are organizations like the Home Builders and Remodelers organizations that have programs already in place that would help out, and they actually are in some schools doing this now, that would help out teaching the middle schoolers.
Thank you for that explanation. Are there any additional questions from members of the committee for Representative Ackert? Representative Cooley.
Thank you, Mr. Chair, and thank you, Representative, for coming in. Speaking about more exposure with the middle schoolers, it sounds as if you're kind of advocating for the old junior high structure that I was taught in a number of years ago, in which you had the 7th and 8th graders, and they would be exposed to different portions of the trades with metal shop, wood shop, your home ec, and other things. For me, probably one of the most valuable was learning how to sew, because it got me a job I could actually study during in college, which was very helpful for getting into grad school. But it seems that you're arguing that we need to go back to that old structure in some way, so that the kids are exposed, so that they have the choice by the time they're looking at high school. Do I want to go to a vocational school? Do I want to go to a VOAG school? Do I want to go to a specialty school, as opposed to just funneling everyone into the kind of traditional public school, which has been kind of the policy for the last about 30 years?
Yeah, I think this targets it more during the summertime or more off schools. Like as somebody that sat in education committee for a long time, I hated adding more mandates to the school district. Oh, we need to add this. But I think that a course or two, just to let people know what it is, actually you're building life skills also. Maybe not have to be a career. It's life skills, just, doing some basic things in your own home or support. I mean, I remember the college, college painters, all these college students in the summer, they're like, hey, hire us to paint, so there's some of this could be just, added life skills and extra work, rather than not just thinking it's going to be their career. But, I think that anytime we can give, somebody the ability to learn a little bit more outside just the scope of, the higher ed that we look at, and look at the trades, I got to tell you, the trades that I know of are in need of workers, and they're paying. And they have benefits. So I look at it as, sometimes, that 6-digit salary doesn't have to come with that nice thing hanging on the wall that says, my doctorate degree. It can come with a set of tools around your waist. But we need to open those avenues up for those good paying jobs also. That's why I suggested added section 3. Thank you for the question.
Thank you for the answer.
Are there any additional questions for Representative Eckert? Seeing none. Thank you very much for your testimony, sir.
Thank you all. Thank you for what you guys do.
Right. Joining us remotely, I'm sorry, in the room, Representative Veach. Representative Veach, I think you brought a constituent as well, correct? Yeah, I see that. You can go ahead. Do you want to introduce your constituent? Feel free to sit over there. Representative Veach, feel free to take a seat over there too, if you'd like, wherever you'd like, whatever is most comfortable for you.
I get the low seat. Oh, that's okay. Good morning, everybody. I am Representative Donna Veach, District 30. I have my constituent here. Although I have submitted written testimony, I prefer that she speak on the matter. Michelle.
Good morning, everyone. Madam Chair, Mr. Chairman, and ranking members, my name is Michelle Fisher-Paul. I'm from Berlin, Connecticut. I'm here today to explain why I support HB 5340. Representative Veach and I have been working together on this issue for over a year. This bill proposal requests that institutions of higher education allow victims of intimate partner violence to participate in any investigation or administrative hearing conducted by such institution in cases where the accused is a student or employee of such institution, but the victim is not. This is a result of a very personal situation. CCSU mishandled the investigation and hearing process of a violent intimate partner assault on my daughter. Her abuser was a CCSU student, athlete, and she was not a CCSU student. Immediately after the assault, we proceeded in the legal court system and also filed a misconduct report with CCSU. The CCSU Director of Student Rights and Responsibilities collected medical records, police records, information, and testimonies from us and various people. She often referred to the CSCU Code of Conduct as our guide in the investigation and hearing process. In her sporadic communications with us, she led us to believe that my daughter and I would be included in the actual hearing at CCSU and be allowed to provide testimony at that time per the Code of Conduct policy. However, after 10 months of working with her, CCSU held a private hearing without us, and this was devastating. They blindsided us and left us in the dark about the hearing's outcome. They did not follow what was stated in the code in respect to victims' rights to participate in the hearing, nor the how, what, and when the hearing outcome would be communicated. I reached out to the director who did the investigation, as well as President Zulma Toro of CCSU, an interim vice president, their Title IX coordinator, and a ranking CSCU member, but I got no answers. My FOIA requests were also denied. So therefore, I filed a whistleblower report with the Attorney General's office. The investigating attorney told me, in summary, that he can't tell universities what to do and that universities have no obligation to include or disclose anything to a victim who is not a university student. I challenged this because of the wording in the actual Code of Conduct. I immersed myself in the code and I found that all parties and entities involved in the code were defined except for the victim. There is no definition of victim, yet victim rights are clearly stated throughout the articles pertaining to misconduct investigations, hearings, and outcome of the communications. It does not distinguish between students or non-students. It simply states victim. A friend of mine who is also a CCSU professor heard from his colleagues that our case was handled as such because, quote unquote, the abuser student athlete was not in a current relationship with my daughter, and also because my daughter was not a CCSU student. I then contacted Representative Veach and told her about our situation and the need to change the language in the CSCU Code of Conduct to better support non-student victims. At the same time, I also started a change.org online petition regarding this issue. As of today, I have 436 signatures. This says a lot about how our community wants the same change. Many of the commenters on my petition were also victims themselves who were ignored by universities. And a copy of my petition and the signatures list and other supporting documents have been uploaded through the testimony portal for your review if needed. So today I'm humbly asking you to consider moving this current bill forward. Too many victims of intimate partner domestic violence are never seen or heard. These crimes continue to happen on Connecticut University campuses without justice or recourse for the victims. Students and non-students alike who are victims of intimate partner domestic violence at the hands of a student should have the same rights in the university's investigation and hearing process regardless. Thank you for your consideration.
Thank you very much for your testimony. We appreciate it. Although, you know, I'll tell you that I regret hearing the details of your case. I guess I'm sorry that you come away from this feeling like Central Connecticut State University has not treated you or your daughter well. We in this committee, we've worked very hard over a number of years to try to ensure that colleges and universities, all colleges and universities, but particularly public universities, are responsive to the needs of complainants in these kinds of cases. And seems like that may not have happened in this case, and so I regret that. A couple of questions. One is in the course of your experience, do you think the problem lies with the policies at Central that were not clear enough to provide a complainant who is not a student with the ability to participate, or is the problem with personnel at the university who weren't applying the policies appropriately?
That I don't know. I immersed myself in the code trying to understand why the decisions were made on by CCSU to exclude us. I spoke to many attorneys in the process as well, figuring out if I was going to take legal action against CCSU for not following their own code of conduct. And there seems to be a very gray area in that victim, as I mentioned, victim is not defined as an entity or a person in the code of conduct, yet victims' rights are stated. So I believe that perhaps CCSU council interpreted the code of conduct to exclude non-student victims, but it's not stated that way anywhere. So I don't know if it was something that CCSU personnel did incorrectly, or they were just following council's advice on that gray area as to what a victim is.
Oh, okay, thank you. My follow-up question to that, I guess, is, there's the institution would probably find guidance in several areas about how to proceed, right? They have their own policy. They have, state statutes that govern the way they deal with these kinds of allegations in these kinds of instances. And then there's also, the federal sort of Title IX
Right.
regulations. I'm wondering, to what extent have you been able, or Representative Veach, been able to sort of put all of those things together to figure out whether or not one or another of the places that would govern these instances conflict with each other, and that might have provided with, central with the justification for working through the case the way they did.
Well, having never gone through this process, and I hope to never have to do that again, I, again, immersed myself in the code and researched, where did that code come from? What laws apply to the code in which the CSCU Board of Regents, constructed their code of conduct. And in contacting every single one of those people, President Toro, the interim vice president of CCSU, the Human Rights and Responsibilities Organization, Title IX person, I referred to, state statute this and this says, says a certain thing, which is supported also, transferred over into the code of conduct, yet it wasn't followed. Can you tell me why? And they would never give me an answer. So.
I mean, this is unfortunate, but well, let me ask one last question. Can you tell me when the assault occurred and when the complaints were filed? Just looking for a timeline.
The misconduct report was filed the day following the assault.
Right, and date, like a roughly month and year.
It was May 2020.
Right.
So it took over a year, almost a year, 10 months for CCSU to go through their process, almost another year for me to try to get the answers as to why CCSU excluded myself and my daughter, and then another year to get some sort of input from the Attorney General's office for my whistleblower complaint. So it's been a very long process.
Yeah.
But so the report was, the misconduct report was filed with CCSU 2 days after the incident.
Yeah. Unfortunately for you, and I think maybe for other victims who are out there, the time frame that you're talking about was somewhat tumultuous in this area because longstanding precedents and policies that had been established by the United States Department of Education governing Title IX and the way colleges and universities deal with Title IX were changing at precisely the time frame that you're referring to. It was a significant initiative by the administration at the time, and it was Commissioner DeVos, to limit the extent to which Title IX is applicable to instances like yours, instances that of assault or intimate partner violence that happen off campus, where one or both of the where one of the members is not a member of the university community, and so what you end up having is a series of guidance and laws that sort of are sometimes can conflict with each other. And that's why I'm asking a question. I'm trying to figure out where does the problem lie? And how do we, where do we go to find a solution to it?
And at the time of this incident, I wasn't aware of the changes in
Yeah.
Title IX. All I was given was the code of conduct from the CCSU administration as my guideline on what to expect. I would have no idea, I wouldn't even know to look into what
But-
Title IX legislation was changing or the conflicts
No,
in the verbiage. So I was just going with what I was given and then doing my own research.
yeah, no, I completely appreciate that. And, as somebody who, actually, I thought a lot of the changes that were being made at the federal level were headed in the wrong direction personally. What we were told here additionally is that in those instances where state law supersedes, it conflicts with federal law, that it's the federal law and the regulations that would supersede the state law. But that in those instances where state law went further than federal law, that the state law would apply. And so it gets to be sort of a hairy mess. And unfortunately, when this stuff happens, the people who are most dependent on these policies to provide resolution and clarity oftentimes, are victimized again. And, that's unfortunate. And it seems, I don't know that that's what happened here, but I know that was a very, it was a period of time when Title IX officers and colleges and universities were struggling themselves with trying to figure out how to revise their policies and comply with the federal regulations at the same time as complying with what I think are very strong state regulations. And so I'm not saying that as a way to excuse what they did. Actually, I think it's an unfortunate consequence of what was happening at the time. But my sympathies are with, obviously with students who, are victim to intimate partner violence and sexual assault and discrimination and, all of the other things that we outline in our statute that I think, really necessitate a strong response by colleges and universities. And I regret again that did not happen in your case.
In this particular instance, when I did reach out to the Title IX representative at the time at CCSU, she was completely unaware of our case. However, according to the Code of Conduct, a Title IX representative should be present at the initial review board of the misconduct report. So I was very shocked to find that, she was not on that review team. And I asked again, how could that be? And got no response.
Yeah. And the last thing, has the university ever cited FERPA as a reason why they could not share with you the results of a process that was being adjudicated on campus?
Yes, they did. And that was their claim to why they did not disclose anything from the hearing, was because the information was FERPA protected. I called the FERPA hotline to get an explanation. Again, I'm trying to do my own research here. And the woman that I spoke to said that that certain information is indeed FERPA protected. However, in the Code of Conduct, it does specifically state that the alleged and the victim will be notified within 1 day of, I believe it's 1 day, within 1 day at the same time of the outcome. So it doesn't say anything about FERPA. It just says that the outcome would be communicated to both parties at the same time. The FERPA representative also said that nationwide, there are a multitude of cases similar to mine where non-student victims are rejected from getting any kind of outcome because universities are claiming FERPA protection, and therefore there's a whole bunch of lawsuits against, claiming that. I didn't push it as to what states, and it's like trying to find a needle in a haystack, what lawsuits have taken place outside of the state of Connecticut. But she did say that, a lot of colleges, universities will claim FERPA protection and not disclose anything despite what the Code of Conduct would say.
Thank you for your testimony. And again, I know that these kinds of occurrences can have a devastating impact on families and on students who have to, who are who fall victim of intimate partner violence and the other really criminal conduct that we're trying to address here. And I wish the best to you and to your daughter in the future, and I hope that she's doing well. Are there additional questions? Senator Slapp.
Thank you, Mr. Chair. And yeah, I just want to preface by saying, I'm so sorry for what you and your family and your daughter have endured. And I think it's really, beyond admirable to, you're coming here today to, I think, not only, of course, advocate for your family and your daughter, but also for all the young women, and not just women, but all the people, of course, right, who are coming after and wanting to improve the state. So thank you for your advocacy. Just a couple kind of background questions. One, was there a criminal investigation?
Yes, there was.
And can you just kind of describe the outcome of that and what happened?
The alleged was given a, he was referred to the Family Violence Education Program. There are, from what I learned, 3 tiers to the program. We had pushed for the 2nd tier, considering the injuries and his intent when he committed the assault. Unfortunately, the judge thought otherwise, and he was given the minimum, which is 13 sessions at 1.5 hours each of this education program. And if the alleged had no further incidents with the law, his record would be removed, expunged, and that was that.
And was anything about the investigation, now not the criminal one, but the one on campus, communicated to you, or even after it concluded? Was there any communication to you about that?
No. After their investigation and hearing took place, there was no further communication, even though I did reach out to the investigating director, President Toro, and interim vice president. I, talked to the higher level CCSU people, but they said the case was closed. They will not disclose anything to me. So therefore I, submitted subsequent FOIA requests and things like that. But no, they refused to have any further contact with me.
Okay, thank you for your testimony, and I'll hand it back to my co-chair for additional questions from other members. Thank you.
I see Representative Turco has a question.
Thank you, Mr. Chairman, and thank you both for bringing this issue to the committee. And I'm sorry about everything that you and your daughter have gone through, the difficulties with this, but appreciate you educating us on this. Just one question. I was wondering, in your research throughout here in Connecticut, maybe looking at other colleges and universities, public, private, or nationally, what you've learned, is this an unusual way that CCSU handled this situation, or based on, their guidebooks for handling it compared to what else you've seen out there?
Well, there are Clery reports that are published by all universities on an annual basis, but unfortunately, they're many years in arrears. So like this year might reflect information from 2021. It doesn't reflect current information, and there are very little details as to what is included in those Clery reports. But as far as other Connecticut universities, I know there was a big case at UConn a couple years ago, and there was a $1.3 or $4 million settlement for the victims of assault that had occurred on campus that the university basically neglected to acknowledge. I reached out to that attorney to see if she could, help me in my case, and unfortunately, she was no longer practicing. So as far as any other Connecticut State University, I don't really know if this is common. I don't know. I don't really know. And part of the reason why I'm here today is to prevent this situation from happening again and again on any Connecticut campus.
Thank you very much for that. Thank you, Mr. Chairman.
Any additional questions? Seeing none, thank you very much for your coming. Thank you, Representative Beach, for raising our awareness of this issue.
Thank
And
you for your time and your consideration of our request. We
yeah,
appreciate it.
we appreciate your testimony, right?
Thank you.
Joining us online is several folks from Chifa and Chesla, Jeanette Welding, Josh Hurlock, and Dan Karowski. My understanding is that you are going to sort of work together to offer comment on several bills in front of us today. Is that accurate, or are you going to go one by one?
No, we're going to work together. I'm going to provide some oral testimony, and Josh and Dan will be available for questions.
Great. Thank you very much. You can proceed.
Okay, thank you. And good afternoon, co-chairs Senator Slapp and Representative Haddad, and distinguished members of the Higher Education and Employment Advancement Committee. I'm Jeanette Weldon, and I'm the Executive Director of the Connecticut Health and Educational Facilities Authority, also known as CHEFA. And I'm here today to provide testimony in support of SB 304, SB 305, and sections of SB 13 on behalf of CHEFA's two subsidiaries, the Connecticut Higher Education Supplemental Loan Authority, known as CHESLA, and CHEFA Community Development Corp., known as CHEFA CDC. CHEFA is a quasi-public agency that issues tax-exempt revenue bonds on behalf of Connecticut's nonprofit hospitals, universities, and other qualifying nonprofit 501c3 organizations. CHEFA and its subsidiaries do not use taxpayer dollars to support their operations, and our staff are not state employees. The proposals contained in SB 304 will enable Tesla increase access to post-secondary educational opportunities for Connecticut students by amending Tesla's enabling statutes to allow Connecticut students under 18 years of age to enter into student loan agreements with Tesla. This will bring Tesla's capacity to provide financial assistance to Connecticut students in line with its counterparts in other states, as well as with the federal government, and help more Connecticut students access Tesla's cost-effective financing rather than resorting to other higher rate options. Additionally, SB 304 will allow Tesla to use a letter of credit or surety policy to fund the Special Capital Reserve Fund, which backs our bonds. This will give Tesla the ability to fund the reserve fund without using bond proceeds, and therefore use more of its proceeds to fund student loans. SB 305 would expand CHEFA's current childcare programming by creating the CDC Early Childhood Education Tax Credit Program. This program will create a state income tax credit for businesses in exchange for their investment in childcare facilities located in childcare deserts. Employers can claim a 75% tax credit for contributions to the program, and CHEFA is proposing an annual cap on total contributions received of $10 million, with a tax credit totaling $7.5 million. Entities eligible to receive support through the program include licensed child care centers and fiscal agents for licensed family child care homes and group child care homes. Child care facilities can use funds from the program for construction, renovation, equipment, and working capital expenses. CHESLA also supports language in Section 2 of SB 13 that establishes the High Priority Occupation Loan Subsidy Program. This program will provide an interest rate subsidy for targeted occupations as determined by the Office of Workforce Strategy in consultation with CHESLA, and help address workforce shortage areas. The loan fund to support this program will need to be funded by the state, as the reduced interest rate loans would not be able to support repayment of debt service on a CHESLA bond issue. Lastly, CHESLA supports language in Section 1 that expands the current tax credit for employers that make payments on their employees' student loans. Changes in Section 1 would allow employers to claim a tax credit for payments made on any student loan, not just a Tesla loan, and we think this expansion will be mutually beneficial for employers and employees. Tesla can help all employers implement this program through an employer loan repayment program we developed in partnership with RISLA, our Rhode Island counterpart. This program offers a turnkey solution for providing student loan repayment on behalf of employees. So thank you for your time, and I'm joined today by my colleagues, Josh Hurlock, Assistant Director of CHESLA, and Dan Karowski, Manager of CHEFA CDC, who can assist in answering questions.
Thank you very much for your testimony. One question I had about the governor's bill, and I want to acknowledge that this is the governor's proposal. It did not come from CHESLA, correct, or CHEFA? It's SB 13.
Correct.
And that is, so what it, and if we had talked briefly about like your desire to accomplish a similar goal, we have established a number of different incentive programs targeted at certain occupations and that the legislature believes needed additional support to meet the state's workforce needs. And my understanding is that by doing that piecemeal, you believe that has added to the administrative burden that it takes to sort of implement and create and start those programs. Is that sort of a summary of the motivation behind this legislation?
Yes, we think it makes more sense to have sort of a comprehensive approach as opposed to piecemeal, as you said, with multiple programs patterned after each other.
Right.
Right, and just to add on to that, like each new program, there's a startup cost of at least $50,000. So if we can consolidate it into like one program, you reduce the administrative cost.
So as we roll the different initiatives that are in state statute into a single program, my question is, what's lost? Who decides what occupations or what what the specifics are about the workforce incentives are?
So it provides for consultation with the Office of Workforce Strategy to provide input on, what are the high priority occupations and what's needed, and where the workforce shortages are, what can be incentivized.
So the Office of Workforce Development is the one that would help choose who gets the incentives? I'm sorry, is that what you just said?
The Office of Workforce Strategy would be the primary entity identifying, what are the workforce shortage areas that need some sort of incentive.
Is there any role for the legislature in that process?
The way it's written, my understanding is it's primarily Office of Workforce Strategy in consultation with Cheslin.
Right. So I'm looking at section 7 of the bill, I guess. And again, this is not your bill. This is the governor's bill. But I just wanted to highlight it because I'm wondering what legislative input there is to deciding how these programs are. I know that there's legislative input now because we passed laws that you are required to implement within available sources. But section 7 repeals 10A-19E, 10A-19F, 10A-19I. These all represent different initiatives that the legislature felt was important, but are all being repealed and swept away by section 7 of the legislation. Is that your reading? That's certainly the way it sounds to me.
I believe there were some sections that were being repealed in order to implement it under this more of an umbrella kind of comprehensive approach. And I'm not specifically familiar with all of these sections, but I think there were some things that passed in the last session that have not been funded, for example. So they're not operational. And so I think the concept here is to try to, combine them into a more, as I'm saying, comprehensive approach and then move towards funding from there.
Right. And I don't think repealing those prior statutes, I don't think the intention is to necessarily not have those programs. I think the intention is to maybe incorporate those programs under this umbrella subsidy program.
Yeah, so I see in section 4, in lines 152, 153, and 154, a number of statutes. I haven't done all the cross-referencing myself either, so I'm asking these questions. It looks like there's a number of programs that have been previously established by the legislature that specifically says you shall administer those programs. The Section 7 is a different category of programs that looks like they're being eliminated. I guess, we'll just have to be careful about what we're adopting and retaining and what we're eliminating. One specific question that I have, and it's interesting because we have another piece of legislation in front of us that's up for public hearing that tries to revitalize the Kirkland Kerr grant program, which is 10A 19G. That is one of them that's specifically referenced in Section 4. That is a program that had previously been funded and administered by the University of Connecticut. And I guess maybe this moves it to the Office of Higher Education. We'll have to look at that, but I thank you very much for your testimony. I guess, I'm generally supportive of the idea of eliminating overhead costs, but also just want to make sure that the voice of the legislature isn't overlooked in the rush to sort of expedite the administrative part of the program. So I appreciate your testimony. Are there any questions by members of the committee?
Could I just make just one point of clarification? Section 4A, I guess line 151, that's referencing Office of Higher Education in that paragraph, not CHESLA. So it'd be the Office of Higher Ed that's administering the programs, not CHESLA. And I'm not sure what those programs are, but I think it's different programs than what we're referring to.
I see. So you're suggesting maybe that's existing. That's not the operative change in the bill is those references.
Well, that's not the change we're speaking to. We're speaking to the change as it relates to CHESLA.
Understood. Okay. I'll have to look up 10A-169B because that's what seems to be what's being deleted from the statutes in Section 3 and 5. But I appreciate that clarification. I appreciate that. Are there any additional questions by members of the legislature, the committee? Representative Johnson.
Thank you, Chair. Thank you all for testifying today on these bills. We did receive some testimony about SB 13 that where it's noted that the nonprofit community has some concerns because they are not considered as part of the definition of small business. I was wondering if you could provide us some insight on what you think would be a path forward to perhaps include them and or take consideration of the fact that many graduates want to work in the nonprofit field, and that is a crucial part of not only our social safety net, but also many of the helping professions moving forward, working through private and public.
Can you just clarify what section you're referring to? That'd be helpful.
We received general testimony concerning that. I believe I'm understanding it, small businesses are given tax credits, which is a major thread through the bill, but nonprofits are not considered a part of those who could receive these tax credits, and wondered if you had an official position on that.
I think you're referring to SB 305, which is the child care tax credit proposal. And
no, I'm referring to testimony we received. I apologize. Go ahead. I didn't mean to interrupt.
No, if that's that's our tax credit proposal. And so Dan Karowski may be able to speak to that.
I'm speaking about testimony that we received about SB 13. Now, perhaps the person testifying transposed the bill, but I guess it's a general concern that they see this bill, SB 13, as a tax credit for corporations that does not include nonprofits or small.
Oh, I know. Okay, you're referring to the employer student paid tax credit.
That's it. Yeah, just wonder if you have an official position on the point of view that was expressed in the testimony.
Okay, so I think in terms of the entities and the types of entities that are eligible for the tax credit, I believe that was, it is a governor's bill, so we did not specifically weigh in or impose comments on what type of employers should be able to get a tax credit. Josh, do you want to add anything there?
Yeah, I think I would just add, I think what we're more supporting is the expansion of the tax credit to include any student loan rather than being tailored just to Chisel specific loans.
Thank you. That's really helpful. I appreciate it. And I assume for those listening and watching, if they feel strongly, then I think that's a executive branch question we as representatives should be asking. So I appreciate that information as well about how this expands to include more people. Thank you.
Are there any additional questions? Seeing none, thank you very much for your testimony. We appreciate your time today, and I'm sure if we have additional follow-up questions, you'd be willing to sort of offer some guidance for us. We appreciate it.
Okay, thank you.
Thank
All
you.
right, thank you.
Next up is number 7 on the list, I think. Jumped all the way to 7, and that would be Dean Shawby from the College of Agriculture at the University of Connecticut. Welcome to the Higher Education Committee. It's good to see you. We look forward to hearing your testimony.
Thank you so much. And honorable co-chairs, ranking members, and members of the Higher Education and Employment Advancement Committee. My name is Indrajit Chaube. I am Dean and Director of College of Agriculture, Health and Natural Resources at University of Connecticut. Thank you for this opportunity to testify on behalf of the university in support of House Bill 5338, an act concerning the admission of state residents to veterinary schools. As you may know, the Crackling Curve program began in 2008 and was active until 2018 and was administered by the University of Connecticut College of Agriculture, Health and Natural Resources. The goal of this program was to make it easier for Connecticut residents to secure slots in veterinary doctoral programs, since our state does not have a veterinary school. Since other states without veterinary schools routinely pay for their students to secure slots at out-of-state institutions, Connecticut needs to do the same for its residents. As background, 28 states have veterinary medical programs, while 22 states do not. Connecticut is one of these 22 states that limits the options for students in our state to develop a career in veterinary medicine. This program successfully leveled the playing field for some of our top students. When it was funded, the program was open not only to UConn students, but also to all state residents. After soliciting proposals from many veterinary schools, UConn chose to partner with Iowa State School of Veterinary Medicine because of its outstanding reputation, coupled with the financial benefits it was willing to offer to Connecticut students. The first cohort of 5 students was admitted in 2008, following an evaluation process conducted by ISU. A ranked list was sent to Connor by ISU, and Connor would then reach out to the admitted students while providing information related to the scholarship program. The commitment to each admitted student was $10,000 per semester for 4 years, totaling $80,000 per student. Should you decide to provide funds to this program, and I hope you do, I suggest increasing the appropriation to $15,000 per student per semester, totaling $120,000 per student to reflect Iowa State's increase in cost of attendance over the last several years. Over the life of the program, it became apparent that to ensure students could be assured of stable funding throughout their veterinary education, Connecticut needed to provide the full cost of attendance for each student upon acceptance into the program. Basically, we realized we needed to front-load the entire cost for each student admitted to Iowa State so that the students knew their entire 4 years of veterinary school were locked in at the discounted rate made possible by state appropriations. Additionally, I would request an additional 10% of the total appropriations to be allocated to Connor to fund the cost involved in administering a successful program. This program was extremely effective in expanding access to our top students. Not only did the commitment from the state secure admissions for up to 5 Connecticut residents each year, but the support from the state also reduced the tuition and fee burden to align with an amount equivalent to in-state students. Finally, we received excellent feedback from ISU about the Connecticut students who attended their program. We also maintained a positive relationship with ISU throughout the process and believe we could replicate that outstanding collaboration should this program be revived. Thank you for your consideration and continued support of the University of Connecticut, and I'm happy to answer any question you may have.
Thank you, Dean. Two questions. One is the program, when it was originally established, provided, I guess from your testimony I'm gathering, not just scholarship support for students who were going to, who secured one of the slots that were available or secured through Iowa State, but it also, Iowa State guaranteed that there would be a certain number of positions open to Connecticut students. Is that correct?
That is correct. And that was part of the proposal we had solicited, where we wanted our students to be evaluated separately by these veterinary schools, and Iowa State guaranteed that they will be evaluated similar to an in-state applicant.
Right.
And so therefore our top students had basically a competitive advantage in securing an admission there.
And the number of slots available for programs like this are far and few between. You said, most states, many states don't have any veterinary school at all. But was there a requirement, a service requirement, that post-graduation, those students who secured the degree would return to Connecticut and practice here? I don't recall if that was part of the program or not.
That was not a requirement. We would talk to the students about it. We don't have a number about how many did come back either right after or maybe later in their career. But no, it was not a set requirement.
Are there other states that have programs like this? And would it be wouldn't it strengthen the program from our perspective to ask that in return for getting the scholarship and the benefit of getting increased access to the program itself, that they return to the state and practice here?
So, Representative, you are asking a really good question, and in my opinion, it will be difficult to enforce it. One, number two, when I compare that to our medical school, for example, or dental school or nursing programs, where we are providing state support for our state residents to go to these programs, we don't enforce that expectation that once you come out of UConn School of Medicine, you must practice within the state. While we hope that majority of them, if not all, will practice in the state, that requirement is not there. And so to keep it fair across professional programs, I think this will be something that will be not only difficult to enforce, but would create an inequity, how we are treating medical school, dental school from veterinary school expectations.
Yeah, I thank you for your answer. I appreciate your perspective on it. Are there any additional questions, members of the committee? I see Senator Slapp.
Thank you, Dean, for being here. So this is, I think, the first time in my time on the Higher Education Committee that I've heard the bill. So I'm going to ask some very basic rudimentary questions. So I apologize in advance. But so why is UConn the middleman here? In other words, if we don't have veterinarian school and there's people in Connecticut who want to go and study veterinarian school, why are they going through UConn? Why don't they just apply to Iowa State?
They were applying directly to Iowa State because the requirement was not that you have to be a UConn student. Connecticut resident who may have gone for their undergraduate degree out of state, as long as they retained a residency in Connecticut. Every one of them was eligible to get this scholarship. My understanding, and this program predates my internship at UConn. My understanding is the program started with higher education, and then the funding part was transferred to UConn to make everything at one place and to gain efficiency. We have pre-vet programs across our schools and colleges. Many students who come with the goal to get an undergraduate education at UConn and then go on to veterinary medicine. We understand these programs, and that's why we were asked to administer it, and we will be delighted to continue that.
So, and this is picking up on what Representative Haddad was asking. I mean, there's no requirement for, after the program for residency, for coming back to Connecticut, right, at all. Is that, you understand?
The residents do come back, some to UConn in my College of Agriculture, Health and Natural Resources. But there was no requirement in place that post-graduation they must come and practice in Connecticut.
Do you know of other programs? I guess the argument would be that because we don't have a veterinary program here, that, if we had one, we probably wouldn't have this program, I assume, right? Are there any other examples that you know of that similar, where we're spending Connecticut resources to, and it's just going to sound like a loaded, like I'm arguing against. I'm not. I'm just really kind of trying to understand exactly the rationale behind it, that we're spending Connecticut resources to send students to another state to study program, right? Are there other examples of that you know of?
There are many examples. So Iowa State, with whom we worked, they have similar arrangements with multiple other states. When we were soliciting proposals from practically all veterinary medical schools, and not everyone responded to our call for proposal, but those who responded, they had similar arrangements with other states. Only 28 out of 50 states have a veterinary medical program. 22 states do not, and we are one of those. Many states do have a similar program.
Thank you very much. I appreciate it. I think, go ahead, Representative. There you go.
Thank you, Mr. Chair and Mr. Chair. And thank you, Dean Chubby, for coming and testifying and for your support of House Bill 5338. And I want to particularly thank the chairs for raising this bill this session. So just to give you a little background, so one of my constituents brought this issue to my attention and asked that we try to pursue this. And in his particular situation, his daughter basically lost a year of her education. She had, because we don't offer veterinary education, graduate education here in Connecticut, she had to apply as an out-of-state student, and she was unsuccessful in her efforts, and she basically lost a year until finally she was accepted at an out-of-state school. And I guess the idea is that most of these other schools from out of state are more willing to accept in-state students, and they accept very few out-of-state students. So she was one of the lucky ones, but many of her compatriots, were not so lucky. So I guess that one of the ideas of this bill is that Connecticut residents would be treated as in-state students at these other colleges and universities. Do I understand that correctly?
So that is correct. For admission purpose, Connecticut residents who apply to Iowa State, they were put in a separate category and were evaluated outside the rest of the out-of-state students who applied for the program. So Connecticut students were looked very favorably. And then the scholarship that was made possible from this body brought their cost of education equivalent to an in-state Iowa student. thus making not only veterinary school accessible to them, but also affordable to those students.
Thank you. I'll ask you an easy question. I presume that there is a need for this, and that from what I understand, there is a pretty severe shortage of veterinarians in Connecticut, if not nationwide. Is that accurate?
And that is absolutely accurate. I have my own Dean Advisory Council, and I hear it often from my own advisory board members about this shortage, as well as there is a strong interest from our students who are coming to animal science department as well as Department of Pathobiology. Majority of them have an interest in going to vet school. Many of them are limited either by affordability or by access for the reasons you described.
Yes. So it's kind of sad to contemplate that the University of Connecticut, which started out as an agricultural college, that we're in this position where students will graduate and then, not be able to stay in state to pursue graduate studies in veterinary medicine. But hopefully we can start to remedy that. So just one other question, if I could, Mr. Chair. I presume that you would prefer that actually two other questions. I presume that you would prefer that the administration of this remain with the University of Connecticut as opposed to being shifted over to the Office of Higher Education, for example?
We would be delighted to do that because we have had excellent relationship with Iowa State. We can go back and revise the MOU we had with them. We understand them, they understand the process, but it's not just for the UConn students. We were doing it as a service to all Connecticut residents. And if we are trusted, we will be delighted to start it again.
All right. Thank you very much. I can't remember my second question, so we'll have to wait and maybe do it offline. Thank you, Mr. Chair and Mr. Chair.
That's our good fortune, I guess, Representative D'Amico.
Right.
Are there any other questions? Representative Cooley.
Thank you, Mr. Chair. Thank you, Dean, for coming in. My question is relatively simple. I understand your point that making enforceable that the student has to return after completing veterinary school is not really enforceable. But my question is essentially, with this program, is it a higher probability that those now veterinarians would return to the state of Connecticut at a higher number than veterinarians produced out of state that were not Connecticut residents moving into the state? So essentially my question is, this program, do you see it as producing more veterinarians for the state of Connecticut, which is needed, versus if we did away with this program and we weren't providing this opportunity for Connecticut residents to study it somewhere like Iowa State, and we were just looking up market forces, we'd probably get less veterinarians moving to the state of Connecticut to practice than we get from the return of Connecticut residents going to Iowa State and coming back.
My guess is yes, because of the family ties, because of the background here, because of connections. Many will come back. Many will come back right away. Some will come back later in their career, but those connections to bring them back to Connecticut as opposed to someone who is not connected at all, probability of them coming here.
Thank you very much. Thank you, Chair.
See, Representative D'Amico has remembered his, unfortunately, has remembered.
It
his
is your
question.
bad fortune, Mr. Chair. Yes.
For the second time, Representative D'Amico, go
Thank you
ahead.
for your indulgence.
I'm sure it's an important question.
Thank you for your indulgence. So just for a clarifying question for you, Dean Chaubey. So does this Kirkland Kerr program still exist on the books? And is it the fact that it's not funded? Is that the issue?
That is the issue. We may have to go back and revise the MOU we had with them, to reflect the current numbers and how many and at what level these students will be funded. But the program is still in the books.
Great, thank you. Thank you, Mr. Chair.
Thank you. Are there any additional questions? Seeing Representative Turco. Yeah, join the party.
Thank you,
Representative
Mr.
Turco.
Chairman. I just wanted to ask, do you see this program being back as operational and funded as an important recruitment tool for undergraduates that want to enter into a veterinarian program, but by UConn not offering one or having a relationship and partnership with Iowa State like we do now, not having that being available, perhaps they prefer to go to a different school for undergraduate that could have a easier transition to the graduate program?
So that's a really good question. I have the numbers. There were between 2008 and 18 when this program was in place, we had 40 students who went through this program, and 20 of them were UConn students. Other 20 were not UConn students. The students who came to UConn, we would talk to them during the freshman orientation, those who had an interest in veterinary school, that this is an option available to them. But the same information was also provided to all Connecticut residents through a website.
Yeah, I mean, I just see it as Connecticut not having a veterinary school, this relationship and, UConn assisting students to be able to go into a graduate program, I think is an advantage to keeping those undergraduate students at least here at one of our public universities. So thank you very much for that.
Thank you. And thank you very much for your testimony. Dean, is your department that's in charge of the UConn Dairy Bar as well?
Yes, that is correct.
And did you happen to bring any free samples today? I'm just curious.
I not today, but I'll be delighted to bring some in future.
Okay, well, I'll remember that for the next time you appear before our committee. I appreciate that. Yeah, thank you very much. I appreciate your testimony today.
Thank you.
Next up is Christina Quaranta. I don't see anybody. If she on, and she's not online. I don't see her online. Next up, Georgia Goldburn. Also not online. I'm sure she's where? Oh, she's here. Great. Thank you. It says remote here, but she's in person. You're welcome to join us in the room. I actually prefer it, but welcome to the committee. We appreciate you appearing before us to offer your testimony, and you can proceed. At this point, we are going to try to limit testimony to 3 minutes, and so when you hear the bell go, you can summarize, and if you go much further, I'll interrupt you, but you can go ahead.
It's my first time before the Education Committee, Higher Ed Committee.
Well, welcome to our committee. We're a friendly committee, I think.
Well, yes, you are, and
Yeah.
I'm pro ice cream myself.
Go ahead.
So thank you, Senator Slapp, Representative Haddad, Ranking Members Haynes and Kelly, and member of the Higher Ed and Employment Advancement Committee. Thank you for the opportunity to submit testimony. My name is Georgia Goldburn. I live in Middletown, and I'm the director of Hope for New Haven, a faith-based nonprofit located in New Haven that manages the Hope Child Development Center. I'm also the co-founder of Circle, a network of childcare providers serving children and families of color. I'm testifying in support of SB 305. As many of you are aware, the childcare industry has long been marked by a brutal economic tug of war. Most families cannot afford skyrocketing high cost of care, while many childcare workers can't survive on their pay. According to Secretary of the Treasury, Janet Yellen, childcare is a textbook example of a broken market. The free market works well in many different sectors, but childcare is not one of them. This is her language. It does not work for childcare caregivers. It does not work for parents. It does not work for kids. And because it does not work for them, it does not work for the country. SB 305 offers a piece of solution to make childcare work for Connecticut's children, families, and businesses. By creating a fund at Connecticut Health and Education Facilities Authority, CHIFA, childcare providers will have access to funds that they can use to expand facilities in childcare deserts. Additionally, they will have access to critical resources needed to stabilize their programs without increasing cost to parents. Moreover, it engages Connecticut businesses as key stakeholders and partners in contributing to solving the childcare crisis. The Circle Network, which is comprised of 38 childcare businesses headed by people of color, serving over 500 children in vulnerable communities in the greater New Haven and Fairfield area, has worked to identify resources needed to keep these providers' door open and to continue to serve their families and communities. While there are increased investments in childcare, these investments are insufficient to meet the needs of providers who need to stabilize their operation. Moreover, providers who have the capacity to expand lack critical access to capital to undertake any such projects. Recently, an RFP managed by LISC on behalf of the Office of Early Childhood Education received requests for funding for about $74 million from over 300 providers looking to expand. The RFP could only support $13 million in request. This highlights the critical need for such a fund as the one being proposed in SB 305. It is for this reason that Circle supports this legislation. Thank you for allowing me to offer testimony in this matter. Perfect timing.
We love you for
Thank
having that
you.
perfect timing. It's great. We appreciate it. And I appreciate you coming and testifying before our committee. I guess you know, in your industry, you don't often have occasion to come to the Higher Education Committee, but we are the committee that has oversight and cognizance over CHIFA, and so that's why you're here today. We appreciate your support. I would only add, I don't have a question for you, but I would just ask that if you have testimony and you have not already submitted it, please do so to the clerk so that we can post that online and members will have access to your opinion moving forward as we review the bill and it proceeds through the legislature.
And I plan to. I found out
Right.
about this bill yesterday, so I didn't get a chance
Yeah.
to submit one.
Thank you. We appreciate that very much. Are there any questions by members of the committee? Seeing none, thank you very much for your testimony.
Thank you.
Next up is Danielle Peachy. I don't see the person in the room or online, so we'll proceed.
I'm
to-
here online.
Oh, I'm sorry. Great. Thank you very much.
Hi,
Sorry for
no,
missing
thank you.
you. You have
Sure.
3 minutes. You can proceed.
Okay, thank you. Thank you, everyone. Good afternoon. My name is Danielle Pickey with Porter and Chester Institute. And we've submitted comments on other bills, but I felt it would be worthwhile to provide just a brief testimonial comments in response to HB 5237 requiring student surveys during evaluation of private schools to renew their certification of authorization. So since 1946, Porter and Chester Institute has been educating students in the areas of medical assisting, dental assisting, CAD, CNT, electrical, and HVACR, and automotive. While all are essential fields to keep our local economies working, the alumni of our schools are now active members of these communities, taxpayers, and are working for employers who are taxpayers. In addition, PCI has supplied the same essential skilled workers as noted above, plus practical nurses, plumbers, welders, and low voltage technicians as graduates for our schools serving in the greater Enfield, Hartford, Waterbury, and Bridgeport, New London, Connecticut areas. We offer affordable short-term programs to our students, thereby saving them and their families time and money as they go through our effectively structured educational programs, enabling them to quickly enter into the workforce in these communities and contribute by their education and skills obtained at our schools. Currently, our federal regulator, ACCSC, the Accrediting Commission of Career Colleges, requires institutions to demonstrate that we maintain attentiveness to our students' education and other needs through student surveys performed and to provide a temperature check of the students. This is a great tool that gauges institutional effectiveness in the areas of admissions, financial aid, student services, and instructors' performance and training interactions. Should any of those areas result in a below benchmark set by the commission, schools must provide an analysis of the reasons for the low student satisfaction rates in any of those areas evaluated by the commission. The school must provide and implement corrective action plans to improve those areas that had low student satisfaction ratings. And the commission will request that we provide regular updates to requiring the school to resurvey students and to monitor the efficacy of the institution's efforts to improve student satisfaction rates. While we welcome making surveys an active part of the student experience, however, sometimes unfavorable surveys could trigger an unfavorable interpretation by the approving agency. Adding survey requirements could produce additional survey fatigue that many of our students already experience, and they may lead students not to provide a thoughtful or truthful responses. So there needs to be just a clear delineation and benchmarks of the desired results and a due process or show cause for allowing the institutions to implement improvement plans that should be reviewed by the reviewing agency to find survey results unfavorable, causing this but we don't want this to be a disqualifying event for a license of renewal, and just ask that, that they take into consideration that this surveys be modeled similar to our accreditors. Should this bill pass, Porter and Chester would be a willing partner in reviewing or helping with the drafting survey language. Thank you.
Again, thank you very much for your testimony. So I just want to make sure I understand what you're saying. So there are opportunities for students to engage with I guess it's the accreditation process is what you're talking about.
Yes.
And you're not opposed to having student opinions be included in the licensure or the renewal process, but you want to ensure that those questions are similar to the questions that are being posed during the accreditation process?
Yes, that's correct. Yes. So there's not a whole bunch of a duplication of efforts. And
understood. Okay. Thank you. Are there any additional questions by members of the committee? Seeing none, thank you very much for your testimony. We appreciate your sharing that perspective with us. We'll keep that in mind as the bill moves forward.
Thank you.
Next up is, I'll ask if Beth Hamilton is here. Giselle Morales.
Yes, I'm here.
Great. Why don't you proceed? Thank you for joining us.
Thank you. Thank you, Chair and members of the committee. My name is Jasiel Medallas, and I am an MSW student at the University of Connecticut. I am here to support House Bill 5339. And why I'm in support of House Bill 5339 is because I believe that education is a great equalizer and great empowerer, and all of us here are in a position due to the education that we've received, or at least because of what we know. The issue right now is that not everyone is given the same opportunity and access to that education. This bill will protect our most vulnerable students so that they can have the same rights we have all been blessed to have. The Common App is a standard higher education application that students use to apply to colleges and universities. The Common App removed the criminal history question in 2019, and it also removed the disciplinary history question in 2021. And once they did, there was a significant increase in the rate at which minority applicants complete applications for higher educations, because these questions were shown to be roadblocks, because the students, as soon as they saw the question, they decided not to finish their application. The Common App reports that 31% of Black applicants and 21% of Latinx applicants of colleges and universities using the Common App were deterred because of the completion of from completing the application. So what are we talking about? We're talking about suspensions and expulsions. And of course, our schools, we want them to be safe, but let's see why these students were suspended: due to insubordination, disrespect, obscene language, attendance, and because they had their phone. These types of suspensions make up 61% of suspensions due to the data provided by CT Voices. Studies supported by the Office of Juvenile Justice and Delinquency Prevention highlight education as a primary protective factor against delinquency. American Association of College Registrars and Admissions Officers in 2019 articulate that impeding access to higher education at the gate is a call for national concern. Delinquency is the highest for young people between 15 and 19, and it starts to taper off after. It is imperative to keep young people in school and not unintentionally create barriers for their access to higher education. Thank you.
Thank you very much for your testimony today. Are there any questions? I see Senator Slapp has a question.
Thank you for your testimony. One quick question. I know you didn't write the bill, but I just wanted to ask you, since you're testifying in support of it, whether you draw any distinction between admittance to the school and let's just say if the school has a residential component, housing placement, because the bill as it's written says the admissions process, which could be considered, I don't know, a little vague. And so I'm just wondering if you would support any delineation between, being able to get admitted into the school, without anyone looking at disciplinary records versus, do you think they would be appropriate for the schools to look at them when, for an example, considering on-campus housing requests?
I would support that they be admitted to school, even if they want to be in a dorm at the school as well.
All right, let me just make sure I understand. So you are in favor of shielding this information, right? Both for being admitted to the school, but also subject to like housing application. Is that correct?
Correct.
Okay. Thank you very much. I appreciate you clearing that up
Thank
for
you.
me.
Representative Turco.
Thank you, Mr. Chairman. And Giselle, thank you so much for that testimony. I really appreciate you sharing the different reasons why somebody is suspended. You mentioned 60% of the suspensions were based on issues like using the cell phone, attendance, really minor issues. Is that data from Connecticut or is that national data?
Yeah, that's from Connecticut.
From Connecticut. Thank you. And I'm really, this is why we have public hearings, because you educated, me on that, which, because when I first read the bill, I had some concerns because I know when we review applications through the admissions process, and I was a former admissions counselor, we're encouraged to take a holistic approach. Most colleges and universities now have done away with standardized testing like the ACTs and the SATs for review towards acceptance. So you're looking at, everything you can about an individual that's included in their applications besides GPA and class rank, like what activities they're involved in, community service, their letters of recommendation. And when looking at a holistic approach, seeing areas where they may have, gotten into some trouble gives a full picture of the individual and how they've maybe overcome from that and learned their lessons. So I would ask you, do you see any distinction then between the suspensions that someone could receive that, like you said, could be rather minor things like using a cell phone, or expulsion, which I'm assuming is a much higher threshold and a much more serious manner that the individual was removed from the school?
Absolutely. I mean, like you said, it has to be in a holistic approach. So I understand that sometimes students are suspended or there's expulsion because we'll take an example like a firearm. But when you look at this holistic approach, a lot of these students don't live in safe neighborhoods, and this is the way that they feel safe. But that only happens when you have a conversation and when you talk with the students. And see why these things even happen in the first place. So even in expulsion, of course, there's a distinction that's in suspension, but like you were saying, there has to still be a holistic approach. There still has to be a why, because again, these are students, these are young people, very young, and it's sometimes we're treating them like full-grown adults. And even in colleges, as we know, we're still growing and learning, and not even our brains are completely developed yet. So yeah, of course, there's a distinction. However, I do believe that there still needs to be a further looking into it further. And a lot of times we just see a suspension as expulsion and we cross it off, right? So that's why I draw the distinctions.
Thank you very much for that. And I can't remember on the Common App, but maybe you know from your research, when you check the box, you've been suspended or expelled, or you had some sort of school disciplinary action. Is there a box where somebody could input additional information they want to be reviewed with their application?
Yes. Some there is definitely. And you can explain. There's some of the schools, however, do have further questioning and further applications where they have to also check off if they were suspended or if they were expelled from school. The other thing that happens is that some of these students, they were suspended, but because they had really good behavior, it was wiped out of their record. But somehow these schools, with further investigation, find out that they were suspended, and then they penalize the student for lying, for not putting that they were expelled or suspended, even though they were told that it wasn't going to be on their record, and it's used against them. So even though the Common App does have these abilities, the schools still find a way to find out more information and dig deeper.
Thank you. You've certainly given me a lot to think about. I appreciate your responses to those questions. Thank you, Mr. Chairman.
Are there any additional questions? I just had one, and it refers to that expungement process that you were just talking about. I know that in the statutes, we have we give students the ability to expunge their school disciplinary record. I think it might be the principal or the superintendent who you can appeal to have that record expunged. Is that your understanding as well, that that's a decision that's made at the local level to wipe clean a school disciplinary record if the student has applied and that the local Board of Ed considers that to be the appropriate thing to do at the time?
It is definitely a local thing that happens, and that, yes.
Is it so you said that doesn't work sometimes, I guess, because there's a difference between a question that says, have you ever been disciplined, and a question that says, have you do you have a disciplinary record? And I mean, I really don't know. In the criminal side, I don't know if it's the same applies for people who have had their criminal history, if they've been pardoned, which I think most people understand is a way of sort of wiping clean a criminal record. This seems to be patterned after that. What do you think about the idea of clarifying in the law that if your record has been expunged in accordance with the state statutes, that institutions are not allowed to treat that student differently than somebody who has not had a record that was expunged?
No, I would support that too. I also wanted to clarify that there's not all the colleges in Connecticut use the Common App. And so, like I said before, like even if there's further, like the University of Connecticut and CCSU, they have further questioning on the history and disciplinary history of students.
Thank you for your testimony. Are there any additional questions? Seeing none, thank you very much, and we appreciate your perspective.
Thank you.
Next up is on the list is Merrill Gay. if he can make it back to the room before we get through the next 6 people, he'll be in luck, I guess. Otherwise, yeah, we'll see. Next up, I would be Andrea Dennis. I see you online, and you're welcome to the committee. It's good to see you again, and we look forward to your testimony.
Thank you. Good to see you, Representative Haddad. And good afternoon, Senator Slapp, Senator Kelly, Representative Haynes, and members of the Higher Education Employment Advancement Committee. My name is Dr. Andrea Dennis Levine, and I'm testifying today on behalf of the Connecticut Veterinary Medical Association, the largest professional organization for veterinarians in the state of Connecticut. I'm here to support House Bill 5338, an act concerning the admission of state residents to veterinary schools. Connecticut currently does not have a veterinary school, causing students to attend schools out of state. And some of those students actually take up residency in the state they are attending to take advantage of in-state tuition, and they do not return to Connecticut, where we, like most states, are experiencing a shortage of veterinarians. A recent poll of CVM members has shown that 74% of practices with open positions for veterinarians have experienced timeframes of over a year to fill those positions. I'm one of those hospitals, and it's tough. Meanwhile, pet owners may wait for weeks for routine appointments and surgeries and experience up to 8 to 10 hours waiting for veterinary emergency rooms, with some ERs facing situations where they're unable to see patients at all. Practice owners also report challenges in finding relief veterinarians for vacation or illness coverage. There are currently an average of 45 Connecticut students per graduating class in veterinary schools around the country and abroad. Those students are paying an average of $55,000 a year just in tuition fees alone. That does not include living expenses. Any financial relief would be a benefit to those students. Providing incentive for those students to return to Connecticut would be an advantage for veterinary practice owners and pet owners alike. The CVMA supported the Kirkland M. Kerr program, which was passed into law by the Connecticut General Assembly and provided a much needed financial assistance to veterinary students from 2012 to 2017. We continue to support that initiative and respectfully suggest that this committee consider reinstituting that program as an avenue to assist in veterinary recruitment. Our former beloved Dean Kirkland Kerr, this program was very respectful of him and what he believed in, and it allowed for 5 students per year to be considered as in-state students at Iowa State University Veterinary School for the purposes of tuition and acceptance. Iowa State received $20,000 per student annually, or $80,000 for the 4 years of the veterinary school program, which reduced the cost for the student to the in-state tuition. We believe reinstituting this program will serve as a much-needed avenue for assistance for both future veterinarians and Connecticut veterinary practices. As some of you are aware on the committee, I also have another volunteer role as a member of the UConn Board of Trustees, and I work with students frequently, and especially with Dean Shabe at the school or the university, or what we call CANNER, the College of Agricultural Health and Natural Resources. And I will remind our dean to make sure he shares UConn ice cream in the future when he comes in front of this committee. Thank you so much for your time.
Thank you for that assurance. We appreciate it.
It's important.
And thank you for your testimony. Just for the record, the banana chocolate chip was my favorite. So, although a number of years ago they reduced the size of the chocolate chips, I'm not sure why.
I do. Our President Herbst like the size smaller. I'm going to blame it on her.
That's what I heard. She's like 2 presidents ago now though.
I know.
Are there any questions for Dr. Dennis? Representative D'Amico.
Thank you, Mr. Chair. Thank you, Dr. Dennis, for testifying in support of the bill. Just wanted to go back to the beginning of your testimony. You referred to the fact that many veterinarians study out of state and then don't return to Connecticut So in light of that, we had an earlier discussion, I guess it was with Dr. Chabe about the possibility of requiring the students who take advantage of this program to come back to Connecticut and practice here for at least 5 years. Is that something that you would favor or that your association would favor?
Yes, we would be very supportive of that. One, in terms of the need, and two, it's just the right thing to do. As Connecticut residents, this is something that they would earn. And again, I think it's important for them to come back and give back to their state. So absolutely, we would support that portion of the bill as well.
Thank you very much. Thank you, Mr. Chair.
Thank you for that response. Is there any additional questions from members of the committee? Dr. Dennis, thank you very much for your testimony with us.
Thank you for your time.
Also online is Delan Singh.
Hi, good afternoon, everyone. Can you hear me?
We can hear you. If you have the ability to turn on your camera, that would be helpful as well. And if you can't, then you can proceed in any event.
All right, thank you. Sorry, I can't turn on the camera because at work and I work with children, so I have to have, permission. Anyhow, thank you for giving me the opportunity to testify. I'm here to testify against SB 305. My name is Delan Singh, Director of Occupational Fund Daycare and a proud member of Circle. There are many barriers to early childhood education that affects families and children all over the state, such as childcare desert, where there's no access to early childhood education due to lack of providers, there are too many children, and insufficient childcare facilities to serve the children. High-quality Head Start is cost-effective, leaving low-income families to seek alternative cares from family members. Children whose family come from a low socioeconomic status and are enrolled in child care center program exhibit enhanced development skills such as cognition, language, memory, reading, math, and decreased behavioral problems. Early childhood programs that deliver high-quality child care showed enhanced skills and positive behavioral outcomes from children. They're more likely to attend college, purchase a home, and live a healthy lifestyle. Research shows that poverty hurts both children and parents because it affects mental status, causing stress and a lack of authoritative parental style, which in turn affects cognitive abilities of children as well as their social and emotional well-being. Children who come from families with a low SES are susceptible to delaying cognitive abilities distinguished by diminished expressive and receptive language, reading, math, and independence. The lack of infant and toddler child care caused an enormous financial burden totaling $122 billion in expenses yearly affecting the United States economy, of which $1.5 billion is comprised by Connecticut alone, resulting in a burden to taxpayers and employers paying $1,640 and parents delving out an additional $1,740 in form of generated profitable income tax revenue and lost wages consisting of $5,500 for employed parents. According to the U.S. Census data, 26% of families are single parents. In 2019, 11 million were spearheaded by one parent without another adult in the home. Access to affordable childcare is difficult for African-American women, with a staggering 58% mothers being single parent compared to 48% of Hispanic mothers and 17% of Caucasian mothers, all of which who have children that are young and require early childhood education. That's why I'm supporting SB 305 that will enable parents and providers to make space for availability for incoming children. Thank you.
Thank you very much for your testimony and sharing your perspective with us. Are there any questions from members of the committee? I don't see any, so thank you very much. We appreciate your sharing your perspective with us. Next up on the list is Don Schubert. Here in the room. Welcome to the committee. We appreciate the opportunity to hear from you. And
thank you. Good afternoon, chairs and members of the committee. My name is Don Schubert. I'm the president of the Connecticut Construction Industries Association, and it's a nice opportunity to be here with you today. We were also joined with the Connecticut Subcontractors Association in our written testimony in support of Bill 302. And this bill caught our attention because recently we had a discussion with some of our members where we didn't realize that the apprenticeship tax credit only applied to C corporations in the construction industry. And we were talking to a couple accounting firms about that, and who had represented a lot of smaller construction companies that are LLCs and other corporate forms. And we noticed that there were other groups in that were could get the tax credit that way. It was applied to all business entities. I think it was the plastics industry. And we were considering coming up this year and asking to have it expanded to other corporate forms in the construction industry. And this bill caught our attention right away. So we're here to support voice our support, not only expanding the apprenticeship tax credit to other trades, but also expanding it to other corporate forms. And the only other comment I might have on the bill is I noticed that some groups have a $7,500 tax credit and construction has a $4,000 tax credit. And of course, I'm in a rather unique situation right now where we actually have a technical high school student that is in the Carpenter's Apprenticeship Training Program while in high school, employed by an employer. And this changes a lot for me. Typically, a union employer will go to the union hall and get an apprentice. Now I'm asking construction employers to invest in high school juniors and seniors for 2 years while they're in high school. We can't put them in full production work, but we can get them started in their career early. And I just think that that little bump to $7,500 might help me with convincing employers, to make this an extra investment. We already make the investment through our collective bargaining agreements to pay for our apprenticeship training programs. And now I'm asking them to go a little bit further and invest in a high school student for 2 years. And again, that's my support for the bill. It caught my attention, and I'm very happy to be here today with your committee.
I'm just curious about that, those high school students. Do they do that as part of, they do that after their school day is over, or is it done in conjunction with the local school
Yeah,
district?
the Connecticut Technical Education and Career System has been absolutely amazing. Their work-based learning programs have been in place for years. We learned that if a student is involved in work-based learning, or if they're involved in a pre-apprentice or apprenticeship training program, they can work in a hazardous job like construction at 16. When I first learned about work-based learning, I visited the schools and I went to the principal and one of the directors of the program. And I said, we have a lot to offer these students. What can we do? And I found out that my problem was, in order to get into a union apprenticeship training program, you typically had to be 18 years of age. You had to have a driver's license. You had to have a high school diploma or GED, and you had to pass a drug test. I went to all the different unions and I said, we need to change that. We need to change our entry criteria so we can start bringing in high school students earlier. And the Carpenters Union did it. Now to be a union carpenter, you have to be 17. I'm trying to get them to 16. You have to be 17. You don't need a high school diploma or GED. You don't need a driver's license, and the technical high school system's taking care of the drug test. So we actually had 2 students for our pilot program, but Electric Boat raised the ante and took one of them. Imagine being a high school student and having the opportunity to choose between a construction trade job and a job at Electric Boat. I mean, it's amazing. My eventual goal is to get down to 16 because these students can actually be employed full-time their summer before their junior year. But during their junior year, they can work 2 days a week full-time during their shop time. Their senior year, they can work 3 days a week during their shop time. And if all their educational requirements are met, they can work full-time starting in January of their senior year. This is a tremendous opportunity for high school students. I'd love to see high school students graduating, making more money with better benefits than their parents. Hopefully we can get there, but I just think that maybe bumping up this incentive a little bit might help me a little bit along the way. And this bill did catch our attention because most of our construction employers are not C corporations. They're other types of business entities.
Thank you for your testimony. Are there any additional questions? Yeah, Representative Farrar.
Thank you to the chair. Nice to see you 2 days in a row, different committees. But it just means this is important, right? I do have a question about the other section of the bill that is about pilot program for grades 4 to 6. I just was curious your thoughts on that component of the bill.
We had some discussions up here last year about getting into the middle schools.
Mhm.
I think that it's never too early to start. Before I took on all these different jobs, I used to go into kindergarten classes and build birdhouses and teach people how important it is to measure and read and write. But I think as far as what we're learning is a lot of students are graduating high school and they don't have aptitude to enter the trades. And I think it's never too early to start them. So they can be aware that they have to build the aptitude to be able to build things and understand the way things are built and work. I did have an experience many years ago when we were doing a construction career day program. I sat down with a table full of high school students, and one of the students commented, "This is the first time in my life I realized I could do something." It was a shame he realized that in his senior year of high school. We could have started him a lot earlier. But I think we can't start early enough. I think that, well, years ago, when we talked about education reform, we talked about student success plans. Remember starting in 8th grade where a student would create a student success plan. We had created I was chairing the Employment and Training Commission at that time, and we had created some career pathways that we thought would start at the middle school stage. So I think it's important. I think, I think that there's a lot of very good career opportunities for students, other than direct college. Myself, starting construction, get a good job, then go to college and go to law school. You'd be surprised how many construction people have followed an untraditional career path and an untraditional education. But I think when it comes down to Section 2 of this bill, we can't start early enough.
Thank you for that. I did note to myself, given your sharing as well, is I know we have taken the steps to develop some of the career pathways programs in middle school. And as federal government, we get Perkins Career and Technical Education dollars to try to provide more funding down to the middle school level. And so one of the things I was reflecting on and seeing this is how could we better align what is already happening in the schools with career pathways with the Perkins Career and Technical Education dollars that are focused on those particular skills to this program. And I hope we could do that if we set this up appropriately.
Yes, I
Yeah.
think making the connection between education and workforce is huge. And I think the sooner we can make that connection, the better off we all are.
Yeah, thank you. Thanks for being here. Thank you to the chair.
Thank you. Are there any additional questions? Representative Cooley.
Thank you, Mr. Chair. I'd like to thank our individual testifying for coming in on this bill. You mentioned Section 2 and the importance in terms of middle school students getting exposed. In terms of the trades, we have the issue of manual dexterity, which is incredibly important to be able to handle precision tools. My takeaway from your testimony so far is that it's really important that the middle school kids get that exposure in terms of manual dexterity so that can be prepared to enter the trade that most suits them. Is that one of the reasons you're supporting the Section 2?
One of my jobs, or one of my opportunities that I have is I sit as a trustee on the Operating Engineers Apprenticeship and Training Fund. And when someone applies for that fund, they have to take an aptitude test. And I'm always surprised by the number of applicants that can't pass the aptitude test. We grew up building things at home and cutting, working with tools and things like that. And I think that there's a lot of students out there that don't have that kind of exposure. And I think that if there's some awareness in the middle school level, that those students may seek out, opportunities to work on vehicles or equipment or manually handle things or start learning how things work and, are put together. And it would only help them, I think, succeed, as they go through their high school education. But I really think that having that just aptitude to understand how things are built and they work is very important. And, you know, we took, and just from my perspective, I may be completely wrong, but we took a lot of that wood shop and everything out of the schools years ago, out of the comprehensive schools. And they don't have exposure to those things. But I think the sooner the students get exposure to the trades, the more they can work towards a goal, or they can work towards something that they really like, or they think they might be able to do in the future. And these are well-paying jobs. And, you know, the thing with the construction industry is, and I tell everyone this, the sky's the limit. You know, I hear stories over and over again, like myself, where people entered the construction industry with no experience at all. And 10 years later, you know, they have a great education and they're in very high-level jobs. So, you know, in my mind, it's a great pathway. I don't talk about construction jobs anymore. I talk about careers, because we have a lot of work. We've got a generation's worth of work ahead of us right now. And these are real career opportunities for people.
Thank you.
Any additional questions? Representative D'Amico.
Thank you, Mr. Chair. Thank you, Mr. Schubert, for coming and testifying. So I'm just looking at testimony from the Commissioner of the Department of Labor, specifically regarding Section 2 of Senate Bill 302. And she says that she expresses concerns about placing young students in hazardous working conditions. And this bill contemplates, you know, this program for kids in, I guess, grades 4 through 6. Is her concern justified?
Yes. We've had that discussion. Oh, we're having a lot of discussions right now. I just wrote an article, is 16 safe? We're having a lot of discussions, right? I'm trying to encourage these well-settled apprenticeship training programs that you don't have to be 18 anymore, that 16 is safe. I've also am having discussions with the employers that are hiring these students, that if you're going to hire a student, you're going to treat that student like any entry-level person coming into our industry, right? You're going to make sure they have a mentor. You're going to make sure you evaluate their skills and experience. You're going to have someone watching them constantly and working with them, just like anyone else. You know, we're very safety oriented. It's our top priority. But we are having those discussions, and I'm trying to convince people right now is 16 safe. I envision a middle school program very different than full production work, or work in a warehouse or a facility where we're actually, or a production facility. I think that a middle school program is more of an awareness program than actually getting out there and doing things. They may be able to touch certain equipment and operate certain things, but I think it's more of an awareness that, you know, this industry is evolving. There's a lot of technology now, and it's more awareness than actually putting them in harm's way or putting them out in a work zone on a highway at midnight.
And I appreciate all that, and I don't mean to be a buzzkill here, but for fourth grade, that's not middle school. Those kids are 9 years old.
Right. Yeah.
Is that a little too aggressive?
I don't know. You know, it depends on what kind of awareness program we're going to expose them to, and we're very aware of that. You know, that's why we're having these long discussions right now. It took me a year to get the carpenters to go to 17. You know, it's going to take me a couple of success stories to get them to go to 16. It's going to take me to have this pilot program work where everyone is safe, you know, and make sure that we have some good success just to bring it down. But I don't think we're talking about a construction experience. I think we're just talking about exposure to the industry, you know, exposure to all the different trades or opportunities they may have at a young age is really good for people.
I don't disagree, but thank you for that clarification. Thank you, Mr. Chair.
Thank you. Are there any additional questions? Seeing none, thank you for your testimony. We
No,
appreciate
thank
you
very
taking your
much.
time
Nice
with
to
us.
be here today.
Next up, Paul Amarone, also in the room today. You'll be followed by Mark Albin, who I see is online and has been waiting patiently. Oh, I presume, I don't know, maybe he's waiting impatiently. And then we'll go back to Merrill Gay if he can make his way into the room. But for now, the floor is yours, Mr. Amarone. We look forward to your testimony.
Thank you, Senator Slapp, Representative Haddad, Senator Kelly, Representative Haynes, and members of the Higher Education and Employment Advancement Committee. Thank you for the opportunity to present testimony today. My name is Paul Amarone. I'm the Advocacy Outreach Manager at the Connecticut Business and Industry Association, state's largest business organization representing thousands of member companies, both small and large. I'm here today to testify in support of Senate Bill 302, an act expanding the tax credit for qualified apprenticeship training programs and establishing a pilot program for children interested in the trades. As the state's largest business organization, one of CBA's top priorities is supporting our members' ability to recruit, attract, and retain its employees, notably in the trades industry. With nearly 100,000 job openings in the state of Connecticut and a significant wave of retirees expected in the next 5 to 10 years, businesses are putting an emphasis on their ability to train and employ young, skilled workers. This requires a significant investment in their businesses over the next several years. Senate Bill 302 aims to expand the tax credit for businesses employing apprentices through existing Department of Labor guidelines to additional apprenticeship programs across a broader variety of businesses in the trades, including small businesses already hiring apprentices. Senate Bill 302 will also establish a pilot program for students in grades 4 to 6, which will provide students with education and resources regarding career opportunities in the trades. With a growing emphasis from the state on creating more workforce housing, upgrading our electric grid system, and making investments in infrastructure, it's essential that we have a workforce that can meet these needs. Senate Bill 302 provides a larger scope of businesses than ever before with the opportunity to make investments in the future of their workforce through a comprehensive apprenticeship program. Simply put, this will encourage more manufacturing companies to hire apprentices. This also comes at a time when the Connecticut Technical Education and Career System has hundreds of students graduating each year that can utilize an expanded apprenticeship pipeline into a long-term sustainable career path. We support the committee's efforts to bring this bill forth, and with that, I look forward to any questions.
Thank you for your testimony. This is a simple question. I'm almost embarrassed to ask it. This sets up a pilot program for grades 4 to 6. Do we already have a program for grades 7 and 8?
There are existing programs throughout the state for middle school students. There is not in grades 4 to 6. I do understand that concern, Representative D'Amico. I do hear your concern. I would like to echo what Don said. I think this being a pilot program, it's open to how we would want to set it up. I don't think exposing kids in grades 4 to 6 to being on the floor like someone who's an apprentice might be at age 18 is acceptable. But I do think education and awareness is something that is certainly acceptable. I don't think anyone's too young to be educated on something, and gives them an opportunity to decide and kind of broaden their horizon when it comes to deciding on a career path later in their life.
Yeah, just as a follow-up to my question, were the programs that are established for grades 7 and 8 through 8 also legislatively mandated, like we're doing here for grades 4 through 6?
I'm not aware if they're legislatively mandated.
Are there other barriers that I'm not aware of? I mean, if we didn't legislatively mandate the programs for 7 and 8, I guess I'm wondering why what gets in the way of establishing programs for grades 4 to 6?
Well, I think the key here is it's a pilot, right? I think the language is very broad. There's not a ton of detail right now in the language, and I think that's why I'm here today, as CBI is happy to be at the table to get our members in the business community together to talk about what can be in that pilot program and what can't. I think the concerns that were brought up earlier are certainly things I expected to be brought up today. But again, I think that there's room to grow and room to collaborate on what is included in that pilot program, not something permanent that we just kind of put into place and then have to deal with down the road.
Yeah, okay, I appreciate that response. If
Yep.
there are additional questions, I'm going to call on Representative Cooley, followed by Representative Farrar.
Thank you, Mr. Chair. I'd like to thank you for coming in and testifying. This is kind of a comment of clarification, since I actually hold a teaching certificate, even though I was a college dean for a long time. I've worked throughout the system. From a historical perspective, the old junior high school model, which was the model that I grew up with and I studied under, you'd finish 6th grade, graduate, and then go to junior high school, and that's where you would be exposed to the trades for the first time: your wood shop, your metal shop, your home exits, culinary, etc., and then divide out after that. One of the things that did happen is when we went to the middle school model, all of a sudden we took 6th grade and lumped it in with 7th and 8th. And it kind of created an anomaly, because the old system, like if you get certified, I'm certified to teach social studies. My certification is 7th through 12th grade. If you have elementary certification, it's 1 through 6. So you kind of have this dividing line in terms of certifications in the old system, in which middle school model didn't exist. And I think some of this is, we're looking at legislation coming in and looking at the old traditional 7th, 8th grade model, and how do we expand it to 6 through 8, and going with the 4 through 6 state definition of upper elementary, which still exists in certifications. So I'm not sure that this is would be 4 through 6, or it's 6th grade connecting to 7th and 8th graders that would be under the old structures of traditional trade exposure. Would your organization be opposed to just limiting this to 6 to add to 7th and 8th, as opposed to going all the way down to 4th, so that it's the actual middle school model is being included in this, as opposed to 4th through 6th, which is the old upper elementary, and then junior high, which is already included. We're now adding 6, because so many school systems now don't use the junior high model. They use the middle school model, but I believe a lot of our regulations still are based on the old elementary, lower elementary 1 through 3, upper elementary 4 through 6, junior high 7, 8, high school 9th through 12th grade. So would CBIA be opposed to just it's 6 through 9, as opposed to all the way down to 4?
Yeah, I wouldn't say we would be opposed to that. Like I said, this is a pilot program. I'm not sure how much it would mirror what you were referencing from the past. I think there's room to collaborate on that. But I would absolutely not say we're opposed if the bill were to be modified to say, grades 6 and above, or whatever it might be. We'd be happy to be at the table. I think our main thing is there are a lot of job openings in the state right now. As Don was saying before me, there are a lot of great career opportunities in the trades, and there are also a lot of retirees coming in the next 5 to 10 years. And we hear from a lot of our smaller members in the construction and trades industry that they're having trouble getting young skilled workers. So whereas a pilot program for students in high school or college might be a little bit more hands-on, require a little bit more working with machines and tools. A pilot program for students in whether it's grades 4 to 6 or 6 to 8, would be a lot more educational and informative, as opposed to hands-on work on the actual job site.
I just, okay, it's just an anomaly that I kind of understand why the anomaly exists, and that would kind of bring it into middle school. as opposed to sliding all the way down into elementary school. So it's just something possibly to think about going forward. Thank you.
Thank you. Representative Farr, did you have a question?
I did, thank you. I do recognize our discussion is running into likely more education committee related discussions, but just following up, I think, on Representative Haddad, your question and Representative Cooley's comment. Question for you. I know the bill is written in reference to Department of Labor piloting this program. Would you have any concerns if it was considered that the State Department of Education did this, given their engagement in more of these programs already?
No, I wouldn't have any concern with that. I think as long as the collaboration doesn't kind of fall with, we're doing the most of it and you're not doing the other half. I think there just needs to be conversation so everyone knows exactly what their role is. Yeah. That's my only concern, but I don't think we would be opposed to that whatsoever.
Okay. And just kind of going back to the discussion and your comments on the age, the way I had seen it, because there are particular federal dollars, Perkins Career and Technical Education dollars, and dollars from our school districts already going to middle school age, grades 6 to 8. I view the way this was written was trying to do even earlier exposure and trying to dedicate some funds to that earlier exposure. And given that, I think the other question I kind of have for you is, in the requirements that our school districts have for the use of those career and technical education dollars, there typically has to be a focus on making sure that those programs are engaging more underrepresented populations in some of those fields. And so I wanted to ask you directly if you would be open to, let's say we establish this pilot program and look at this legislation. Are you open to seeing the value of kind of that focus on individuals who are more underrepresented in the trades being more highly kind of engaged in this type of pilot program?
Yeah, certainly. I think, when we're looking at our workforce, we're looking at our students, whatever it might be, we certainly need to take that into consideration when making those decisions. And I think a lot of it also has to do with the appetite throughout different school districts in the state. And, we're CBIA is right down the street here in Hartford. And I know that there are a lot of students who might not even be aware of the opportunities in the trade. So, the Hartford Public Schools might be a great place to get into over other districts that might have a little bit more education on that right now.
Thanks for the comments, and thank you to the chair.
Thank you. Are there any additional questions? Seeing none, we'll move on to the last person on our list.
Thank you.
That's the luck of the draw, Mr. Albin, but the floor is yours. We look forward to your testimony.
Thank you very much, Mr. Chairman. Good afternoon, committee. My name is Mark Albin. I'm a small animal veterinarian that currently practices in Middlefield. I'm happy to be here today to help on behalf of the Connecticut Veterinary Medical Association, offer support for House Bill 5338, an act concerning the admission of state residents to veterinary schools. The national shortage of veterinarians is certainly felt here in Connecticut. Finding veterinarians to fill positions at hospitals is a challenge for every animal hospital with such a need. Recently, the hospital that I work for, Powder Ridge Veterinary Hospital, was fortunate enough to add a new associate. But throughout the hiring process, we learned that she had offers from 17 other veterinary hospitals to choose from. So we were very fortunate to get her services. But as a result, many of the animal hospitals in our state are understaffed, and pet owners face delays in getting their animals appointments for wellness visits, sick visits, and surgeries. In addition, as Dr. Dennis testified earlier, our local emergency rooms are at the brim, with sometimes waiting times as long as 10 to 12 hours. There are many students from Connecticut that aspire to become veterinarians, but the path to veterinary school for them is very challenging. Currently, there are only 32 accredited veterinary schools in the United States. Only one of them is in New England, which is Tufts. and Tufts does not guarantee any seats for Connecticut residents. With no in-state or regional options, students from Connecticut must apply for highly competitive at-large positions at public veterinary schools in other states, having to pay more expensive non-resident fees, or attend private veterinary schools, which can be even more expensive. Student debt after 4 years can easily surpass $300,000 to $400,000, depending on the school. And I'm learning this firsthand as my son is actually going through the application process as we speak. The Kirkland Kerr program in its previous form was a great system because it actually guaranteed 5 chartered seats at Iowa State University for Connecticut residents. And this is a huge deal because the competition for those seats, for at-large seats, is sometimes against thousands of 1,000 to 2,000 other applicants. So highly competitive seats. Having even 5 seats guaranteed through a program like Kirkland Kerr guarantees that students from Connecticut have a better opportunity to further their chances of becoming a veterinarian. In addition, those contracted seats allow these students to pay in-state tuition, which is a huge difference. At present, the difference between an at-large seat, a non-resident seat, and a resident seat at Iowa State is about $30,000 per year and adds up very quickly. So the CVMA would definitely support passage of legislation that would reinstate the Kirkland Kerr program. I do hope that this becomes a first step, though. The American Association of Veterinary Medical Colleges reported that in 2022, 41 students from Connecticut were admitted to veterinary schools in the US. In conversations with this group, they estimate that the national acceptance rate is about 45%, which means that we have to estimate that probably another 40 to 50 students did apply to veterinary school, but were not given opportunity to be admitted. I hope that as we look at this program and started at the original 5 positions, that we may even potentially expand it to further seats, which would be a great investment into the number of veterinarians that hopefully return to our state upon graduation. So I thank you for the opportunity to testify, and I'm happy to answer any questions.
Thank you very much for delivering your testimony. Are there any questions? Representative Cooley.
Thank you, Mr. Chair, and I'd like to thank you for coming in to testify for us. I have a quick question. How important is this for Connecticut's animal husbandry industry that's part of agriculture, having veterinarians in the state? Thank you.
Oh, I think it's very important. One of the, as we talk about the national shortage of veterinarians, the large animal industry is probably hit the hardest. With the number of dairies and other agricultural institutes we have, I think it's very important.
And Representative D'Amico has a question as well.
Thank you, Mr. Chair. Thank you, Doctor, for testifying, and thank you for your written testimony, which is very helpful. So I appreciate that you illustrated for us the difficulty that Connecticut potential Connecticut veterinary students have in having access to veterinary schools. I didn't realize it was that competitive, but clearly it is. Did I hear you correctly that there's potentially a $30,000 difference? Could you just expand on that a little bit?
Definitely. So actually, this morning I went to Iowa State's veterinary school's website, and they quoted for in-state resident tuition $29,261 per year versus non-resident tuition $60,987 per year.
Whoa. Okay.
Huge difference. Huge
Yes.
difference.
Yes, no, that is a huge difference, which makes this legislation all the more pressing in my view. I just want to ask one further question, if I could, Mr. Chair, since the other people who testified before you also discussed this. Would you think it would be a good idea to require the beneficiaries of this program, should it be reinstituted and restarted, would it be beneficial to require them to stay in Connecticut for a minimum number of years, say 5 years?
I do think that that would be a realistic ask. I do think that there would have to be language in the bill to allow for postgraduate training. Just like with medical doctors, veterinarians can go on upon graduation for specialty training in surgery, neurology, theriogenology, oncology, and that requires further training that is not offered in many facilities here in Connecticut. So if there's language to allow these graduates to obtain that training and then return to Connecticut, I think that that increases the odds. I also think in response to a question Dr. Cooley had asked Dr. Shavi earlier today, increasing the number of seats would also potentially increase the number of graduates that return to our state. Other states that contract for their veterinary school seats actually offer or have paid for a higher number. For example, at Auburn University, my alma mater, which is in Alabama, the state of Kentucky actually contracts for 38 seats per year, where their students are allowed to pay in-state tuition. So that sort of investment down the road might even return higher dividends.
Well said. Thank you. I really appreciate it. Thank you, Mr. Chair.
Thank you. And thank you. Are there any additional questions from Representative Cooley?
Thank you, Chair. Doctor, thank you for the elevation in terms of my academic credentials. But I'm one of those rare former deans that holds multiple masters, which is what my institution wanted, being a specialty school. But again, thank you for bumping me up a notch.
You're very welcome.
And
Very
have
welcome.
a good day.
Thank you.
Thank you for the clarification, Representative Cooley. The record will so note. Are there any additional questions from members of the committee? Then thank you for your testimony. I'll just call the only other name on the list that was passed over. That's Mr. Merrill Gay. Is he here? He is not. So that being said, if there are no further people to testify, we will declare the hearing closed. Thank you very much,